Before the jury filed into the courtroom today to hear testimony in the case of the people of the state of New York versus Donald J. Trump, Judge Juan Merchan issued his ruling to the lawyers of what would actually happen to Donald Trump if he were to testify in his own defense in this trial. Now, of course, before the judge issued his ruling about what evidence the prosecution would be allowed to use to attack Donald Trump's credibility as a witness, there was absolutely no reason to believe Donald Trump was going to actually testify in his own defense. Donald Trump is incapable of telling the truth, and that would become quickly obvious to the jury, who would probably find themselves watching Donald Trump commit perjury and probably concluding that they were watching him committing perjury. So there really was no chance that Donald Trump was going to testify. But here is what the judge ruled the prosecution could bring up if Donald Trump were to take the witness stand. The judge said that the prosecution could bring up the fact that, quote, the defendant was found to have violated executive laws, Section 63, by fraudulently misstating the value of his assets for an economic benefit. That's the Attorney General's case in New York. And that, quote, the defendant violated a court order by failing to remove an untrue, disparaging, and personally identifying post about the court's principal law clerk from the website donaldjtrump.com. The court fined the defendant $5,000. And the prosecution would be allowed to use the fact that, quote, the defendant was found to have intentionally violated a court order by making public attacks on the judge's law clerk, despite 2 prior court orders not to do so. The court fined the defendant $10,000. The judge also ruled that prosecutors would be able to bring up the fact that, quote, the defendant was found to have defamed E. Jean Carroll in public statements in 2019 by making false statements with actual malice. And that, quote, the defendant was found to have defamed E. Jean Carroll in public statements made in 2022 on Truth Social by making a false statement with actual malice. And the prosecution would be allowed to confront Donald Trump with the fact that, quote, the defendant stipulated to the dissolution of the Donald J. Trump Foundation to resolve claims by the New York Attorney General that he engaged in repeated and willful self-dealing transactions. So there really should be no suspense tonight about Donald Trump testifying in his own defense. He could not possibly survive questions about E. Jean Carroll, his public attacks on court personnel, with jurors sitting there in the room with court personnel, wondering if Donald Trump is going to attack those court personnel or those jurors themselves. And then there was another powerful indication that Donald Trump cannot testify in his own defense today. And that was when his defense lawyer testified for Donald Trump, saying this: I expect that you will learn that when Ms. Daniels threatened to go public with her false claim of a sexual encounter with President Trump back in 2008, that it was, as the people just said, very close to the election. And it was almost an attempt by Ms. Clifford, Ms. Daniels, to extort President Trump, to which the prosecutor said objection and the judge sustained. So there's Donald Trump's criminal defense lawyer saying that Donald Trump never had a sexual encounter with Stormy Daniels, which Stormy Daniels has publicly described in detail. Donald Trump was alone in a hotel room with Stormy Daniels, while Donald Trump's wife was home with his 4-month-old son at the time. The only people who can testify about what happened in that room are Stormy Daniels and Donald Trump, not Donald Trump's defense lawyer. And Donald Trump is not going to testify. There will never be a moment when Donald Trump sits on that witness stand and says, I did not have sex with Stormy Daniels. And so today, Donald Trump's criminal defense lawyer did it for him. Todd Blanche tried to get away with testifying for Donald Trump in his opening statement by saying that Stormy Daniels' description of her sexual encounter with Donald Trump is false. According to Stormy Daniels, who has spoken about it publicly many times, it was a sexual encounter that did not last long, and that in the pre and post sexual chatter, Donald Trump, among other things, compared Stormy Daniels to his oldest daughter. Stormy Daniels has given us plenty of detail about that. The essence of the Trump defense is that the $420,000 that was paid to Michael Cohen was paid for legal services having nothing to do with Stormy Daniels. Donald Trump's criminal defense lawyers told the jury, quote, "You will hear that he, Michael Cohen, did legal work for President Trump and the First Lady as his personal attorney. You will learn that each month in 2017, Michael Cohen sent an invoice to some of the employees at Trump Tower right here in Midtown for $35,000. And on this invoice, Michael Cohen described his work as payment to the retainer agreement for legal services rendered. The invoice was processed. Somebody at Trump Tower generated a check. The check was ultimately signed, and there was a record in a ledger on President Trump's personal records that reflected the invoice. For 9 of the checks, the check made its way down to the White House, and President Trump signed it. You'll hear that he's the only signatory of his personal checking account, which is why he signed the check. So what on earth is a crime? What is a crime about what I just described? The prosecution's answer to that question was that it was all, quote, a planned, coordinated, long-running conspiracy to influence the 2016 election to help Donald Trump get elected through illegal expenditures, to silence people who had something bad to say about his behavior using doctored corporate records and bank forms to conceal those payments along the way. It was election fraud, pure and simple. The prosecutors said, quote, "We will never know, and it doesn't matter if this conspiracy was the difference maker in a close election." And then the prosecution revealed a communication on election night 2016 between Stormy Daniels' lawyer and Dylan Howard at the National Enquirer, who was part of the conspiracy to suppress negative information about Donald Trump. The prosecutor told the jury, "You will also see evidence that on election night, as news outlets got closer to calling the election for Donald Trump, Keith Davidson, he was the lawyer for both Stormy Daniels and Karen McDougal, texted Dylan Howard at the National Enquirer, and he said, 'What have we done?'" Leading off our discussion tonight, Adam Classfield, who was in the courtroom this morning, in the courthouse today, and who will be there every day for us at the trial. He's a fellow at Just Security. Also joining us, Andrew Weissman, former FBI General Counsel, former Chief of the Criminal Division, Eastern District of New York, and Melissa Murray. They are both NYU law professors and MSNBC legal analysts, and they are the co-authors of the New York Times best-selling book, The Trump Indictments, the Historic Charging Documents, with commentary. And Adam Classfield, you were our eyes and ears in there. You were getting the juror experience of being in the room and taking in all the texture of it all. What do you think the jurors went home with today?
They came home with a lot of information because this was an alert jury. They were wrapped in attention, both in the prosecution and defense statements. And they came home with this bombshell quote that ended your introduction, Lawrence, the "what have we done?" It was almost an Oppenheimer-like moment where you have Stormy Daniels' lawyer with a recognition that, and which is a central theory of the case for the prosecution, that this is related to the election. It was a very powerful moment, and it came within a powerful monologue, which you read part of, that it was election fraud, pure and simple. So that was a very powerful moment. They also came away with, from the defense opening statement, an stop-and-go affair where Todd Blanche was frequently interrupted by objections that were sustained, and the jurors cannot help but have noticed that Todd Blanche kept touching that tripwire.
What about that, though? For the jury, you know, we get the transcript. It's a cold transcript, as they say. Could you feel that the defense was scoring any points at all, capturing anything that the jurors were paying attention to?
There was this one moment where I could see one juror nodding along when Todd Blanche had made the point that it was in this moment where he was saying that influencing an election is not a crime, it is democracy. And there was a moment he was talking, going further into that statement with I'm just kind of turning to the page here, where he was sort of going through that a little bit further. And one of the jurors nodded along. Now, whether he found it persuasive or he just caught his eye, who knows? But it did show that it caught the attention of at least one member of the panel.
Professor Murray, a former president of the United States, has now spent one day of his life as a criminal defendant during testimony in a criminal trial in front of a jury.
And con law professors all over the country the mind boggles at this point, and we're just about to write exams, so this is perfect. This was an extraordinary moment. The idea of a former president of the United States being held to account by a jury of 12 ordinary New Yorkers is truly an extraordinary act. Andrew and I talk about this in the book. These are extraordinary times for us, but again, not for other countries where it has been relatively routine to hold former leaders, even heads of state, to account for their misconduct that was undertaken either before, during, or after their terms in office. And so we have now joined the rest of the world in holding our public leaders to account.
Andrew, we have always been eager in what is now the years we have been covering investigations of Donald Trump to hear a defense. When the January 6th hearings were going on, we were eager to hear what is the Trump defense to what we just heard today. And usually in these forums, there was no Trump defense. Every once in a while, he would tweet something and we'd say, here's a piece of defense. We finally formally got a defense presentation for the very first time today. Did that defense answer the prosecution charge that this was election interference and that this conspiracy, which included the Stormy Daniels payments, was criminal?
So, one of the things I was listening to when the government was going forward was not just what witnesses would say. We know that they'll say David Pecker maybe didn't have a good memory, or he forgot something, or there's some piece that is missing. And obviously, with respect to Michael Cohen, they're going to just say he's just a liar. You heard that today. But there was so many what's called hard evidence. There was references, as Adam pointed out, to phone calls, really critical phone calls on October 26th, when the mechanism that Michael Cohen used was created. And those are phone calls with Donald Trump. There is this record where I sort of fell off my chair, where Alan Weisselberg has written out exactly how the payment scheme worked in his own handwriting on a piece of paper that Alan Weisselberg, the CFO, had asked Michael Cohen to bring. And that was discussed chapter and verse, and it was said, you're going to see that. There were other things like that, and I was waiting to hear, for instance, the tape recording where we've heard about it, but you have to say something if you're a defense lawyer about that. I mean, Donald Trump on that tape is not saying, what are you talking about? I'm not engaged in some payment scheme. Instead, he actually says, can we pay it in cash? I mean, for $130,000.
We didn't hear the defense lawyer. I don't remember the defense lawyer addressing that at all.
So there were just these gaps.
Right.
Right. That, I mean, one of my favorite moments, just to give you a sense of, not to be too partisan about it, but there was sort of a Claude Rains moment when he was talking about Michael Cohen and he had to distance himself. And he said, well, just imagine how shocked that Donald Trump was to find out that his lawyer, Michael Cohen, was engaged in crime. And you were just waiting to hear, sir, here are your winnings. I mean, this was like, straight out of Casablanca. So I think there was sort of a lack of really dealing with the evidence. Obviously, they still have time to do that. They can do that during the trial. They can do that in closing. But in terms of starting the case, I thought, you know what, it's great that that there's a smart jury. They seem extremely well educated. That's going to play well if the other side, if the defense doesn't have an answer for those pieces of evidence.
And Adam, the defense is that, look, this $420,000, $35,000 a month as of 2017 was just the agreed on price for Michael Cohen to be the personal lawyer, they're now saying, of Donald Trump and his wife.
Right. And that's why the point that Andrew made just a moment ago is so important. And Alan Weisselberg wrote it all down, the bank statement that I told you about. Todd Blanche put it out there that there is this alternate innocent explanation for why $420,000 does not equal $130,000. And if the explanation that the prosecutor put forward is in writing and that destroys that, that will stay with the jury in terms of the credibility. And that we have out there from the get-go.
Yeah, and those numbers, that little math sheet's been out there, Melissa, for a long time now. Michael Cohen went public with this description of here's how we did it, and because I was going to have to pay income tax on it to even me up, and oh, by the way, they're throwing in a bonus, so the number equals this. And so it's not new information, and they've had a long time, the Trump team has had a long time to stare at that math and say, okay, here's what we're going to do with it. And they've chosen, sometimes works in defense, the simplest possible approach to it, which is just say, yeah, that's just his paycheck for legal services. That's all it is.
There were moments today where, you read the readout of what had happened and it felt less like The West Wing and more like The Wire. And I remember that scene where Stringer Bell, after discussing, what they're doing with their drug conspiracy, says to one of his minions, like, are you taking notes on a criminal conspiracy? I mean, that's sort of the Alan Weisselberg moment. You literally wrote all of this down. The defense hasn't said anything about the fact that this has been laid out, that Michael Cohen has been talking about it, that we all sort of know how this works. And that's likely because they don't have to. I mean, again, the prosecution has the uphill battle here. They have the burden of proving this case beyond a reasonable doubt on every charge. All the defense has to do is sit back and let the prosecution falter. And so I think part of the defense here is literally just poking holes, like Michael Cohen is a liar. This is built on a house of sand. This will eventually crumble. And as long as they can seed a little doubt in just a single juror, they will have prevailed. And so I think that's what they're sticking to, because I think the other possibilities are much more complicated given the nature of this case.
Andrew, I'm missing a logic point in the defense. I'm going to just assume it's there, and I'm missing it. And that is, Michael Cohen's a liar. So what? My response to that is, so what? In that, what do we need to believe Michael Cohen for? In order to get to a verdict here, what's the credibility issue I, as a juror, need to have with Michael Cohen? Here are the checks. Here's the Weisselberg notes. Here's Stormy Daniels' lawyer testifying that Michael Cohen and I put it all together. There's Michael Cohen's $130,000 going to that lawyer. There's Stormy Daniels saying, I got $130,000. I don't know what it matters. I don't get why Michael Cohen's credibility would matter, since all of the facts of the money movement that he's involved with are established before he opens his mouth.
So that is exactly what the state is going to argue in summation. You were going to hear the defense say, well, if that's true, why did they call him? Because he has a ton of baggage. And so they are saying they really need him because he can provide evidence about, he says Donald Trump knew that the scheme was to have these false business records. Remember, everything's sort of predicated on there being false business records. But it's not like Donald Trump himself is actually, writing the false business records. So they're going to use some of that connective tissue by the state, and the other side's going to say, look, don't believe that. How can you rely entirely on that? And this is where a smart jury is really useful, because you're saying this doesn't logically make sense because you don't even need it, but it's corroborated up one side and down the other. That is why when I did cases as a prosecutor, I looked for the smartest jury possible, because I wanted somebody to think like you. This isn't making any sense. You can say he's a bad person or he lacks credibility, and it doesn't really matter because he's so corroborated. And a lot of times, a jury comes back and they say, "Oh, we didn't really believe him." Somebody like Michael Cohen. What they really mean by that is we didn't need him.
Yeah. All right, we're going to squeeze in a break here. We have so much more to cover in today's first real day of trial. We'll be right back. Today, the prosecutor told the jury about the Access Hollywood video that was revealed by the Washington Post during the campaign, in the last month of the campaign. And the prosecutor said, quote, the impact of that tape on the campaign was immediate and explosive. Those were the prosecutor's words, immediate and explosive. And in our immediate and explosive coverage of that story, the Access Hollywood story, that night on this program, Republican Congressman Jason Chaffetz, in his one and only appearance on this program, came on television that night to withdraw his support for candidate Trump. And we have video of that somewhere in the control room, or maybe we don't.
My wife and I, we have a 15-year-old daughter. How in the world could I look my 15-year-old daughter in the eye and say, honey, you know what? Your dad endorses Donald Trump for president. I can't do that. I can't do, and I won't do that. And that's why I'm withdrawing my endorsement.
The prosecutor then told the jury prominent allies withdrew their endorsements. They condemned Donald Trump's language. You will hear testimony that the Republican National Committee even considered whether it was too late to replace their own nominee and find another candidate for the election a month before the election. And Adam Klasfeld, so the stage was set by the prosecutor for Stormy Daniels, her demand coming into Trump for a day after this, and how important it was for the campaign to stop the Stormy Daniels story from coming out.
That's absolutely right. And that's how the prosecution set that part of their narration up, that the chronology was one day after. And there's an interesting moment about that Access Hollywood, the invocation of the Access Hollywood tape. Of course, during pretrial ruling, Judge Merchan had denied the prosecution's request to play the tape. But when the prosecution had opening statements today, the prosecutor lifted up the transcript and gave this cold actuarial reading that landed with the jury, that there was this moment because of the lack of the tape. There was this cold, crisp delivery of those lines.
He was reading to them the words we've all heard Donald Trump say on the video about his favorite actual method of sexual assault. And the prosecutor read those exact words to the jury.
Absolutely, holding up the transcript and reciting it verbatim. So there was that moment. And one of the interesting things of the entire structure of this opening statement is that it almost backgrounded Stormy Daniels, that it is structured to emphasize the election. It starts with David Pecker and Michael Cohen and Trump meeting in Trump Tower to discuss what the prosecution describes as a three-pronged scheme for favorable coverage for Trump, dirty up his opponents, and be the eyes and ears of the campaign. And that the third prong was in service of the catch and kill schemes. And from there, the prosecution goes to Dino Sajudin, the doorman, then goes to Karen McDougal, then goes to Stormy Daniels. And in that structure, the prosecution is emphasizing election influence time and again, and it's embedded in the structure. And even though the 34 felony counts are tethered to Stormy Daniels, she is almost in the background in the sweep of this narrative.
And Melissa Murray, Stormy Daniels' lawyer is the same lawyer who's already represented Karen McDougal in her deal for her silence. Karen McDougal has a long-running affair with Donald Trump. She, at a certain point, believes she's in love with him. She meets his family in certain situations. There are photographs of her with them. That's a very different story from the one evening that Stormy Daniels has to talk about. And so that story is not being denied in the same language at all, not at all, the way Todd Blanche tried to deny the Stormy Daniels story today.
No, it is unusual. In many ways, the Karen McDougal story is almost more damning, especially in terms of this narrative where everything is set in motion by the revelation of this Access Hollywood tape. And here is candidate Trump, who has tried to portray himself as a family man or now a reformed Christian on the road to Damascus and whatnot. But you have this long-running affair with Karen McDougal and perhaps this one night off with Stormy Daniels. None of it looks great. But yes, Karen McDougal is a big part of this. She's not charged here in large part because the conduct that she alleges falls outside of the statute of limitations. But this is going to be a big part of the story that sort of shows there's a whole range of conduct that this particular candidate and those around him were really invested in keeping from everyone else.
And Andrew, it's Karen McDougal who, in January, after the election, they decide, you know what? We don't have to hold her to the non-disclosure anymore because we're after the election, which is such a key element in incentives here.
Absolutely. So what the state needs to make sure the jury does not sort of go off on is that this was just a scheme with respect to Melania. That's the so-called John Edwards defense.
Yeah.
And so they need to say this isn't just some personal thing. This is about the campaign. So the fact of what he does afterwards. So apparently Pecker is going to say in 2017, he meets with Donald Trump, who thanks him for helping him win the campaign and win the election.
That's all in the opening statement today. Yeah.
Exactly. And so there's just no concern about this becoming public because Melania is going to know about it. In fact, one of the, if this is proved up, is a claim that Donald Trump said, can we just put off the payments until after the election? Because if I win, we don't have to pay. If I lose, we don't have to pay. Because I'm not thinking about Melania. I'm thinking, hey, I may not have to pay this money at all, and I'm cheap. And that doesn't work. They're like, no, they're insisting the money get paid now. So that's why the scheme sort of had to happen on October 26th when Essential Consulting is created by Michael Cohen.
I want to hear you both on your legal reaction to Todd Blanche on two levels. One, Todd Blanche asserting that there was no sexual encounter with Stormy Daniels, in effect testifying for his client who will never testify. Both tactically, was that a wise move tactically, or does that provoke the prosecution in one direction or the other? And what do you do with a criminal defense lawyer who obviously, this is not the last time he's going to try to testify for Donald Trump in this case. He's going to try to testify as much as he can for Donald Trump. What do you do if you're the judge?
So one thing I think you have to sort of recognize about Todd Blanche is he actually spent most of his time as a lawyer on the other side of the V. He's a career prosecutor. He's only had very limited experience as a defense lawyer. And I think you saw some of that today because of the sort of interrupted nature of his opening statement. And some of this was by design. He was testifying on behalf of his client in lieu of his client. But some of it, I think, was he's not up to the rhythm of the way the defense works. And he kept getting interrupted by the prosecution. If you're a judge and you see the defense lawyer doing this sort of thing, I think you do have to step in. And, Judge Merchan did this. But I think at some point there's going to be a sidebar. It's like, the game is up. Like, you've got to stop doing this or we're going to have a real problem. But some of this is by design. Some of this, I think, is inadvertent.
Andrew.
So I think one of the things you may see is a motion by the state saying, here's a litany of things that were claimed as to which we do not think that there's a good faith basis to make those claims now. If later the defendant were to testify, then they can make those arguments. But right now, you should preclude it. So I think they're clearly going to watch their record. A lot of this is a judgment call. It really helps that the prosecution team is really experienced. The judge is incredibly experienced. So he's going to figure out when to sort of lower the boom. But I think that Todd Blanche is not going to get a lot of leeway given his behavior so far.
So 9:30 a.m. tomorrow starts with a discussion of Trump's possible violations of the gag order, which includes no comments about jury. So the breaking news of the evening is Donald Trump's new comment about the jury. Let's listen to what Donald Trump said tonight about the jury.
That jury was picked so fast, 95% Democrats. The area is mostly all Democrat. You think of it as just a purely Democrat area. It's a very unfair situation, that I can tell you.
So to begin with, he's lying about the jury. He doesn't know that they're 95% Democrats. Manhattan is not 95% Democratic. Donald Trump got 85,000 votes in Manhattan. He got 12% of the vote in Manhattan. Adam, this is clearly going to be added to the agenda in that hearing tomorrow.
Absolutely. And the list keeps expanding. We were at 10 before today, and this was one more to add to the list, if not more. I haven't read Truth Social in the past hour or so. It's very clear. The prosecution has asked for a $1,000 fine for each violation. So that could add up very quickly. But beyond that, they want to put Trump on notice that he could spend up to 30 days in jail for further violations. We'll see what Merchan finds. We'll see if he lays down the gauntlet and puts him on notice. But this is explicitly timed, it seems, as a provocation.
Yeah, and Melissa Murray, the jury, this is his second public statement about the jury, very specifically, clearly a violation of the gag order.
Oh, 100%. And again, I think Judge Merchan is principally interested here in securing the privacy and the safety of the jury. I mean, this is a civic duty, a public service. No one is asking to be here. They're doing their duty, and he wants to keep them safe. And I think this is going to be the place where he lowers the boom. Like, this is not going to be tolerated going forward.
Andrew, the day began with Judge Merchan in his chambers with the lawyers from both sides and a juror, an alternate juror, one of the jurors who over the weekend got scared and thought, this is more than I can take, made a call to the court saying, I don't know if I can do this. The judge wanted to hear from that juror today. We've seen the transcript includes what was said there. And it's so completely understandable how this juror was shaken by this. So on a day where the judge begins his day with that issue, jury security, his day ends with Donald Trump making a public statement about the jury.
So, one, I think it will be found to be contempt of court. It is a violation of the order. Two, there's the problem of it being done strategically to manipulate who on the jury is going to have cold feet. We already saw something that appears to have been that last week. So the judge has to be worried about both things. So exactly what Melissa said in terms of protecting jurors and witnesses, but also protecting sort of the composition. So this isn't gamesmanship. I know that Donald Trump is sort of goading him to do this, but, my view is you have to just do your job. Treat him like anyone else. There is no way somebody who did this would not spend some time in jail. I mean, it's just not possible. 11 times the night before you're deliberately violating this with respect to jurors of all things, you would go to jail.
And there's plenty of defendants in that building who spend every night in jail awaiting trial and during trial. Coming to and from jail during trial is something they know how to do. Adam Klasfeld, Andrew Weissmann, Melissa Murray, thank you very much for joining us on this important night. Really appreciate it. Thank you.
Thank you.
And when we come back, Mary Trump will join us to discuss what she believes the jury will see when they look at criminal defendant Trump in that courtroom. That's next. Our next guest, Mary Trump, wrote this about the ordeal her uncle is now going through in a criminal courtroom. In the courtroom, Donald can't speak out of turn. He will be subject to the judge's rules, and a lot of people are going to see certain traits like his thuggishness, his temper, his sense of grievance that may play well to some in certain settings, but that in this setting will come across very differently. He will be seen to be rude, weak, and incapable of controlling himself when bound by the same rules to which the rest of us must conform. There's a reason he tried to get this case delayed until the 11th hour. Even after day one, it was clear Donald wasn't faring well. He's experiencing serious psychological trauma. The narcissistic wound that he's suffering right now is basically short-circuiting him. Joining our discussion now is Mary Trump, clinical psychologist and the niece of Donald Trump. She is the author of The Good in Us, Substack. She is also author of the New York Times bestselling book, The Reckoning, Our Nation's Trauma and Finding a Way to Heal. Mary Trump, thank you very much for joining us on this important night. What do you think was going through your uncle's mind in that courtroom, and what he might be thinking tonight?
First and foremost, probably thank goodness I only sit here for 3 hours today. But other than that, he must know that it's not going well. And one of the things that I find really quite interesting is the extent to which he seems incapable of connecting with the jury. So I'm going to be very interested in seeing how that plays out. But more than anything else, Lawrence, and I know other people have commented on it, but it's incredibly important. It's the extent to which has no control over the situation, and he needs control in order to project the image that he's been able to project for so long. Without that control, it all falls apart. I mean, we know that Donald is a very weak person, or at least some of us know that, and that his ego is a very fragile thing that needs to be bolstered at every moment. He needs the rallies. He needs the applause in the dining room at Mar-a-Lago, because he knows deep down he's nothing of what he claims to be. You know, he's just this frightened little boy. But with the help of a lot of smoke and mirrors and sycophants, he's been able to convince other people and himself that he's actually a successful, tough killer. And, you know, we hear that word come up, but it's a very important word in Donald's psychological history. And without the control, without being able to control the lighting or the temperature, without being able to leave or use his phone without permission, which he probably wouldn't get, it all starts to unravel. And what I think we're going to see in terms of his desperation in his hallway rants before and after, and his inability to stop glaring at people, or, you know, his inability to connect with the people who have, in some sense, his future in their hands, that he can't kid himself anymore about his power and his place and his privilege. And what's probably even worse, he can't kid anybody else either, and he knows it.
I have the feeling he's always been wrong about how he comes across to people, by which I mean, I know some people were completely charmed by him and liked him. I mean this in the pre-politician era. But he always came across as you know, just as Spy Magazine called him, a vulgarian, which I always thought was the perfect, if you were allowed a single adjective about Donald Trump. This is a very, very small-minded vulgarian, and certainly what I've always thought about him. He could never have, you know, charmed me in any way, and most people I know, but he doesn't know that. He never had any idea that there were people who were not just immune to him, but took an active dislike for what he obviously represented. And so his disconnect from the jury must also include this mistake he's made his whole life of thinking that everybody thinks I'm great.
Yeah, and listen, he's had a lot of help. You know, fragile systems bend towards the most dysfunctional person in them. And we've seen this time after time in Donald's life. The ground zero for this was my family, of course. And then it was the Republican Party. And then it was the DOJ, both in his administration and in President Biden's administration. Time after time after time, we've seen that people in those systems make a choice, whether it's Aileen Cannon or Bill Barr or the Supreme Court or Merrick Garland, whether it's out of fear or favor, they intentionally or not, consciously or not, come down on the side of protecting or elevating Donald Trump. So it's not any wonder that he would think that he would be able to control any situation he's in, and that's why we're going to be seeing some very potentially disturbing behavior from him in the courtroom and outside of it. And after 4 or 5 days, it's already manifesting itself.
Yeah, I mean, he's attacking the jury tonight. He's attacked the jury once before in a direct violation of the gag order on him. And that's the first thing the judge has to rule on tomorrow, is how much has Donald Trump violated that gag order.
Yeah, and Judge Merchan is in a similar situation in deciding what side, I shouldn't put it that way, what kind of decision he's going to make. Is he, as Andrew Weissman suggests he should, not going to judge out of fear or favor? And that's what should happen, because the whole idea that Donald is a victim here of anybody but himself, or the whole idea that the system is rigged against him and that it's much more fair to everybody else, is just laughably absurd, of course. And it's about time that this madness stop, because we know that Donald endangers people's lives. And we know that as you pointed out earlier, we've already seen that there are jurors who are understandably quite concerned about how this trial and their participation in it, their willingness to do their civic duty, may put themselves in harm's way, which is just unacceptable.
So Donald Trump's defense lawyer, Todd Blanche, said this in his opening statement today. He's not just Donald Trump that you've seen on TV and read about and seen photos of. He's also a man. He's a husband. He's a father. And he's a person, just like you and just like me. Now, I don't know why he didn't include uncle, since you're out there. But so this point about he's a husband and a father, that's the first time. And I've been in a lot of criminal courtrooms watching trials. That's the first time I have seen a criminal defense lawyer describe his client as a husband and a father without having the wife and the children in the front row of the courtroom. This is something that I've never seen not actually made manifest in the courtroom before. Donald Trump's in that courtroom alone. Jeffrey Dahmer's parents were there every single day. It is very hard to find a courtroom where the criminal defendant doesn't have a relative sitting there in the front row.
Yeah, well, a couple of things about that. First of all, it's another example of how he perverts systems or expectations. For anybody else, that would just be damning, right? Just so the way he talks about dogs would be damning. How many times have we heard that his bizarre behavior, that he engages in bizarre behaviors or just doesn't conform in a way that a reasonably well-adjusted human being would, but like everything else about him, it just kind of gets baked in, right? But it's worth pausing about how unfair, unreal, bizarre, strange, unacceptable, weird, whatever adjective you want to use, it is that he is there alone in terms of friends and family. I think it is worth pointing out, one, I don't think he cares. I don't think it matters to him. That is not where he gets his energy. That is not what gives him solace to the extent that anything does. He's more upset about the fact that there aren't more people outside protesting on his behalf, right? But it also points to the bizarre thing about my family, that every transaction in this family is a transactional one. I'm sorry, every relationship, I should say, is a transactional one. His kids have decided, for whatever reason, that it's not worth their time for them to be in that courtroom because they're not going to get anything out of it. That's the way this family rolls.
I wanted to take a look at that courtroom drawing of your uncle falling asleep in the courtroom. And you know he's consuming all of this news information about the trial. But when he looks at that courtroom drawing of himself. What does he feel when he sees that?
Just an unbearable vulnerability. Again, to get back to the whole killer vernacular, my grandfather needed a son to be a killer. My father did not fulfill those criteria. So it was up to Donald, even though he knows on some very deep level that he is anything but. But in my family, and according to my grandfather, being a killer meant being invulnerable. It is unacceptable, not just to admit you're vulnerable, but to have any vulnerability. That picture is Donald's worst nightmare.
Mary Trump, thank you very much for joining us on this important night.
Thank you, Lawrence.
Thank you. Mary Trump gets tonight's last word.
Hey everyone, MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.